Bago pa po naging hot topic ang immigration sa ating Senado at sa ating mga politiko, pinag-uusapan na natin yan dito sa Kababayan, LA, courtesy of Aquino and Low Law Firm sa ating American Dream segment.
This American Dream segment is brought to you by Aquino and Low Law Firm, answering your immigration questions.
So, Allison, you know, in the spirit of Valentine's Day, last time Attorney Richard Lowe was here, we talked about fiancé visas because unfortunately, you know, immigration has got a lot to do with love and marriage. So you're here, you get married, and then you become a conditional permanent resident. Can you explain that to us? Yes. What does that mean?
The government naturally is concerned about people just getting married for the sake of the green card. So there is a requirement that if you are granted permanent residency within 2 years of your wedding anniversary date, that you are only granted what's called conditional permanent residency rather than the unconditional permanent residency.
And I hear that a lot because then there are some marriages don't work out. And we've talked about that. We've talked about divorce on the show as well. And so we know that relationships aren't always forever. So what becomes of those who married with conditional permanent residency status and then they realize that it's not the right marriage for them, the right partner for them? Are they forced to, is it smart for them to wait? Should they wait till they get their green card, or is there relief available before that?
Well, definitely no one should remain in a marriage simply because they need the green card. And again, the government recognizes that they don't want to bind someone to an unhealthy relationship. So there are ways in which individuals who are in a struggling relationship, who are possibly already filed for divorce, there are ways for them to still convert their conditional permanent resident card to a permanent resident card.
And just last December 2012, there was the I-751 petition to remove the conditions from residence. This is a new memo. Explain this to us.
Well, this new memo actually pertains to individuals who are still jointly filing, rather than individuals who are going through bad relationships. But it is also important for individuals who may be on relationships that are close to perhaps separating. Essentially, under this new memo, it emphasizes the importance of filing the I-751 petition in a timely manner.
Let's first talk about that. Who needs to file the I-751 petition?
Well, anyone who's granted conditional residency, so anyone who is in that new relationship within 2 years.
And you need to be married before you file that?
The I-751 petition can only be filed within the 90 days before your green card, your conditional green card expires. And so that's why people go through the ups and downs of their relationship and may not be able to jointly file, or they might be in a decent relationship and can jointly file that petition. So that memo that came out back in December of 2012, again, emphasizes the importance of filing on time. The main change is that immigration has actually gotten a lot stricter as far as that requirement is concerned. So under this memo, for people who do not file on time, let's say you just forget, let's say you're going through you know, a busy work season, or someone is very ill and you just forget.
Forget to file.
Exactly. So under this memo, you need to file your petition as soon as possible because you need to submit with the application an explanation of why it's late. And previously, what immigration would do is they would go ahead and issue a request for additional evidence if you didn't submit it and give you that opportunity. And then when you submit your reply, if it's questionable, if it's good enough of a reply, then they'll go ahead and allow an interview. Under this new memo, if your explanation is not good enough, they will deny your application. They no longer have to give you that opportunity of coming to an interview and providing your explanation.
So it's important to file right away?
It's important to file right away, and it's important to give a detailed and clear explanation of why it's late if it's late.
Now there's another slide here. Petition is generally jointly filed by husband and wife. All petitions must establish that the marriage is legitimate and bona fide. Husband and wife are separated and are going through divorce proceedings. May still file jointly, however.
Yes, so they can still file jointly, and so
even if they're going through
even if you're separated, or even if you're going to a divorce, say you're on great terms still, or at least on good terms, you can still file your petition jointly. But you need to heed the concerns with, sure, you might be on good terms when you jointly file that petition, but what if things don't quite continue in that same fashion, and your spouse starts not wanting to cooperate in your petition, there is a requirement that if you jointly file a petition and an interview is scheduled, the only way that can be granted is if both of you go to that interview. So if there is a breakdown,
if the other partner doesn't want to cooperate, what happens?
Then if you, your petition would have to be denied. The only way that you can avoid that is if you are going through divorce proceedings and have already finalized the divorce proceedings. Then you can go ahead and convert that jointly filed petition to a waiver petition. So that's why really it's a difficult situation, because you need to assess a good assessment of how stable is that relationship. Do you really want to rely on your potentially soon-to-be ex-spouse in filing that joint petition? Or if you're not quite wanting to rely on that ex-spouse, then you need to move forward with divorce proceedings, because the only way to get the waiver is by being divorced.
But even divorce proceedings can drag for years.
Precisely.
Right.
And that's why timing is important, and assessing, do you need a divorce or are you going to rely on your ex-spouse? That's an assessment that really needs to be made.
Or is there another relief available, some form of, let's say, for example, employment? So can you look into that as well? But I think all these questions are on a case-by-case basis, of course, and that's why you need a lawyer advising you of these things. That's the number to call on the screen to schedule your face-to-face appointment, or you can do consultation by phone, right?
Exactly.
And also email. Thank you so much, and more power to you.
Thank you, Jeanette.